So I'm going to start someone started the recording. Okay, great. Thank you so much to all of our folks who are joining us here today. This is a panel. I'm Charity Ryerson, Executive Director at Corporate Accountability Lab. We're going to be talking today about the Supreme Court decision that came out last week in Nestle v. Doe. Really excited to have you all here, and I am really excited to welcome our panelists, who I think have a lot of unique insight into this issue and are going to help us to really break down this decision and understand it. I will warn everybody that, we're actually, even though Sean comes from a chocolate company, we're actually all lawyers. So we will try to make this accessible, but we also want to make sure that we get into the kind of rigorous legal analysis that I know that a lot of this audience is very hungry for. So before we jump in, first, I want to flag that for anyone who missed it, last December, right after the oral argument, we did a panel with these panelists to debrief what happened in the oral argument, to talk about some of the issues that were teed up before the court. There's a link to that that's now in the chat, so you can look there if you want to go back and watch that. I think it was super interesting, and it might give you some good background. Some of that same information will come up here, but it will be a little bit different. Second, at the end, we're going to have a little time for Q&A. I would just request that you use the Q&A function rather than the chat for the any questions that you have. So in the chat, feel free to use it, discuss amongst yourselves, but for us, we might not have time to read through the chat as we're going. So if you have a question that you'd like the panelists to discuss, please put it in the Q&A. So with that, I'm going to introduce our four impressive panelists. So first, Terry Collingsworth is the Executive Director and founder of International Rights Advocates. He is the former Executive Director of the International Labor Rights Forum. He's filed 11 cases against US corporations for human rights abuses overseas, including against Chiquita, Dole, Coca-Cola, Exxon, Occidental Petroleum, Drummond Coal, and others. Terry and Paul, who I'll introduce in a minute, are counsel for the Doe plaintiffs in this case. And we just posted the IR Advocates website in the chat if you want to learn more about Terry and his work. Second, we have Sean Askinosie. Sean is the founder and CEO of Askinosie Chocolate. We also just posted a link to his company in the chat. Askinosie Chocolate is a small batch chocolate manufacturer in Springfield, Missouri. Sean is also an author. He's the author of Meaningful Work, The Quest to Do Great Business, Find Your Calling, and Feed Your Soul. I actually read some of this book. It's really interesting. And he's been named by Oprah's magazine as one of 15 guys who are saving the world. Askinosie is one of 18 companies who filed an amicus brief in this case on behalf of small and mid-sized chocolate and cocoa companies that Corporate Accountability Lab helped author. Next, I have Beth Van Schuk, who is the Lee Kaplan Visiting Professor in Human Rights at Stanford Law School and faculty affiliate with Stanford Center for Human Rights and International Justice. She was previously the Deputy to the Ambassador at Large for War Crimes Issues in the Office of Global Criminal Justice of the US Department of State, and she co-authored an amicus brief in this case, the brief of international law scholars, former diplomats, and practitioners. So we'll hear a little bit more about that. And then last but certainly not least is Paul Hoffman. He is a partner at Sean Brun, Seplow, Harris, Hoffman, and Zaldez, where he specializes in constitutional and civil rights litigation, human rights, and civil and criminal appeals. He has argued before the Supreme Court 4 times, including in this particular case. He also argued Sosa v. Alvarez-Machain and Kiobel v. Royal Dutch Petroleum, so the sort of biggest cases in this field. He's sort of considered the leading alien tort statute litigator in the United States. So this is quite a panel of folks with a lot of extraordinary expertise, both in the substantive issues and the legal issues. So all of their websites are now posted in the chat. So before we start getting into the legal analysis, I just want us to get situated a little bit in the facts of this case. And Terry, so I'm wondering, can you just remind us, back in 2005, you filed this case. Since 2005, you have been fighting child trafficking in the West African cocoa sector. So who are these plaintiffs, and can you tell us to what extent the experiences of these plaintiffs are representative of what's going on in the industry more broadly?
Yes, thank you. I just put in the chat an article that I wrote for Beth's Just Security that goes into more detail about the plaintiffs and their plight. The plaintiffs were six former child slaves that between roughly 1999 and 2002 were working on cocoa plantations that we think are linked to Cargill and Nestle in Cote d'Ivoire. Their stories are just plain horrible and are typical as well. They were in Mali. They were all very poor, young, 11, 12 years old range. And they, like many children who are trafficked from Mali, they were hanging around a bus station in Sikasso, which is the largest city near the border with Cote d'Ivoire. And typically what the traffickers do is they go to places like a bus station where young boys are hanging out looking for odd jobs. And they tell them, I've got a great job for you in Cote d'Ivoire harvesting cocoa. We're going to pay you a certain amount of money when the harvest is over. All you got to do is get in the truck. So they were all told that, and they all went across the border. The truck then delivered them to a plantation. And it appears in most of the cases that the trafficker knew the plantation owner, and the plantation owner had put in an order for how many kids he needed, and they are delivered. One of the plaintiffs actually saw the plantation owner pay for him, and he thought it was about $50. As soon as they get to the plantation, they're told, nope, in fact, you're going to work here and you're not going to get paid, or we will pay you later. But they're threatened. They're told that they don't work, if they don't work hard, if they don't listen to the directions, they'll starve to death because they won't be fed. And they're taken to a plantation in a country they've never been to. They don't speak the same language. They don't have a penny in their pocket. They don't have a passport. They don't have anything. And they're told to work or starve. The John Doe plaintiffs in this particular case, the conditions were a lot rougher for them than I think they are today, meaning that they were actually guarded. They were locked up at night. If they tried to escape, they were severely punished. One of the plaintiffs had the bottom of his feet slashed with a machete and pepper rubbed in it because he tried to run away. And the others were beaten severely. They have scars on their back. So it truly was slavery. Today, things are slightly different in that the traffickers and the plantation owners have figured out that the kids won't leave, at least for a while, because they don't know where they are, they don't have any money, et cetera. So today they don't do as much beating. They do a lot of yelling, they do smack the kids, but for the most part, they're confident that the kids won't leave until they get a bit older and figure out how they might be able to escape. But you cannot use any word but slavery. These kids are kidnapped, they're taken to a place and forced to work, and they're beaten if they don't work and follow the orders. And that's what happened to these particular plaintiffs, who are still awaiting justice, and we hope we can give it to them at some point.
Great. Thank you, Terry. Could you just also give us a little bit of a sense? I know that since then you've made a lot of trips to Cote d'Ivoire, you have seen trafficked children yourself. To what extent is this still happening, and to what extent are big companies like Nestle and Cargill still importing goods that are produced with that kind of labor, even if it's sort of being carried out in a slightly different way?
Well, yes, every time I've gone on these trips, and in recent years, I've been 3 times, we always find trafficked children. Children are coming in from both Mali and Burkina Faso, which are much poorer than Cote d'Ivoire. And there's a tremendous number of kids that are trafficked. The US Department of Labor's last report on the incidence of child labor, which was performed by the University of Chicago, estimated with their scientific process that 1.56 million kids are there today working on these plantations. So that's not my number. It's a Department of Labor study that funded the University of Chicago. And then they also go on to say that about 95% of those kids are performing what the ILO Convention 182 defines as hazardous labor. They're using machetes, applying chemicals, pesticides, herbicides, and they're working under conditions that the whole world agrees are hazardous and that children should never be performing those tasks. Now, I feel strongly, based on my own experience and research, that the numbers of kids who are trafficked and forced to work is severely underreported. And in fact, this study by the University of Chicago doesn't even attempt to put a number on how many of them are forced. They all say that it's very difficult to determine whether a particular child is trafficked. They're told to lie. They have a story to tell that they were trained to repeat if asked, like where they came from. But when we've gone on the plantations, my colleague, Anja Bo, who always goes with me and translates for me, he can immediately tell that they're speaking with an accent and a dialect that's not from around there. And then he basically busts them when they tell some story. And he says, no, you're from Burkina Faso, aren't you? And the kid always says, yeah. I mean, that's all it would take if you really wanted to check, but it is still going on. There's a huge incidence of it. And these companies are still profiting from the child labor. We've been able to do a lot better job of tracing, like we can identify plantations now that belong to Cargill in particular, which has a huge presence there. So not only have things not changed, they've gotten worse.
Great, thanks, Terry. So, I mean, this is, the need for cases like this or for deterrence for this kind of behavior seems pretty clear. I wonder, Sean, if I can bring you in here. Your company, along with a group of other companies, filed an amicus brief in this case, arguing that, essentially this is an unfair method of competition. Why would a company like yours care about a case like this?
Two reasons. One, because this is a question above legality, and that is of morality. And so we have banded together, we little companies that barely move the needle in the industrial world of chocolate, and say, this is wrong, this is immoral, and it shouldn't be permitted. Of course it's illegal. It just so happened that this particular case had a lane with which the court found grounds to reverse it and not give relief to these poor former child slaves. But secondly, because you can't compete with slavers. It's about as simple as that. If you own slaves and the labor is free, how do we smaller and mid-sized chocolate companies compete with that? Because, and we've talked about this before, but when you go to the convenience store and fill your car up with gas and you're at the cash register and you see a Nestle or a Hershey bar or a Snickers bar, and it's 3 times the size of mine and it costs $1.50 and mine costs 10, you're going to say, oh, well, that's a great value. That value is born of slavery. And so we smaller chocolate makers and at my company realize that this has been going on for decades and we can't compete against that. Now, if I could, just for a moment, say that the answer to this, I think, is what we, smaller chocolate companies, and what we at Eskinosi Chocolate are already doing, which is paying a lot of money for these cocoa beans. So if we put this in context, the world market hovers around, $2,300, $2,400 a metric ton. And oh, by the way, let me drop a footnote and say, and I've said this before and I'll say it many times, when adjusted for inflation, the price of cocoa hasn't changed in 30 years. I can make the argument that the price has gone down. Well, why is that? It's because these defendants and other defendants in Terry's present litigation control the market. So Cargill is the biggest cocoa grinder of anybody in the world. And so when you look at that in that context, you realize that they can control this price. And it's very interesting to me that when you look at other places around the world, like for example, I source cocoa beans in the Philippines, in Ecuador, in the Amazon, and in Tanzania. This year or last year, I would have taken my 46th origin trip. I've never once seen anything that would remotely resemble child slavery in any of these origins. And isn't it interesting that in all of those origins, the farmers make considerably more money for their cocoa beans than the market in Ghana and Ivory Coast, which drives the world market. And I think it's important, and I'll put a link to this if I can, or we could put a link later. Professors from the University of Kansas and the University of Arkansas 2 years ago put forth a study in which they examined an economic model that would have impact on child slavery and the worst forms of child labor if they paid farmers more money. And what they found is that even at 2.8, I'm gonna say it again, 2.8% increase, a 2.8% premium in Ghana would eliminate the worst forms of child labor. And they go all the way up and say, what about a 56% premium on the price of cocoa beans? And they determined that that economic model alone would eliminate all forms of child labor. And you say, well, what is that? Well, It would take it from $2,400 a metric ton to about $3,700 a metric ton. And people, you're saying, but wow, can Nestle afford that much money for cocoa beans? I mean, that would destroy the market. Yes, they can. They can do it, and it will not erode their margin. How do I know this? Because I do it. That's about what we pay for cocoa beans. And we make a profit. I mean, I'm not rich off of this, but this to me is, when we look at this problem, and many of us in the small batch chocolate industry would say, just anecdotally from our observations, that poverty is a cause of this problem. And, Nestle and all these people want to, run whining to the court in defense and say, well, we can only trace 49% of our cocoa beans. We're doing the best that we can. We can't do any better. And you don't need to trace the cocoa beans, and we don't need to worry as much about remediation if we pay farmers more money and make sure that they get this money and they put it in their pocket. And then the market would drive, I think, a solution to this problem. And to Nestle, I would say, you know that you've taken price increases over the years and not complained about it, as you would here. Look, I mean, sugar goes up. You don't think they don't take a price increase when the price of sugar goes up? Vanilla is through the roof. Do you think they absorbed all of that cost? Maybe yes and maybe no. But it's ridiculous for them to say, well, we can't afford to do that. We know that they can. And so to me, I get kind of excited and kind of worked up about this, but I just think that, the chocolate is price inelastic. Consumers are going to do it. They're going to still pay for the chocolate bars. We know that. Study after study says that. And I think we can worry less about traceability if we just pay the farmers more money.
Great, thanks, Sean. I think that really speaks to how this is a systemic problem and that there are actions that companies could take, but they're not being forced to do so. So let's talk a little bit about this decision. So this was a 8-1 decision. These plaintiffs lost. I think we're going to talk a little bit about how bad of a loss it was, and there might be different opinions amongst this group. I'm not sure. So for folks who haven't read the opinion, Justice Thomas wrote the majority. The only dissenter is Justice Alito, which is a really interesting opinion that we can touch on in a little bit. One thing that I found really interesting about this is that we went into this expecting a decision on corporate liability, whether corporations can be held accountable under the Alien Tort Statute at all, and or a decision on aiding and abetting liability, whether or not there should be aiding and abetting liability under the Alien Tort Statute. And instead, we got a decision on extraterritoriality. So I want to kick this to Paul to start us off. So you argued this at the Supreme Court. You had to answer the questions of all the justices. Were you surprised about the basis of this decision? And what impact do you think the way this decision was written has on corporate liability?
Well, first of all, to start with corporate liability, I think that issue is over at this point. We now have 5 justices on record as saying that corporations can be sued under the Alien Tort Statute, and you have Justice Alito saying that corporations don't have any immunity from suit under the ATS, which I think was one of the surprising and positive results of this decision. It's not a holding technically, but I think that lower courts will read the tea leaves and see that a majority of the court now believes that corporations can be sued. And the court, rejected all, or at least implicitly rejected all of the arguments made by the defendants that this is a decision that should be made by Congress, that it's not something that should be done. So in that sense, oddly enough, I view Nestle as a victory on one of the major issues that's been vexing plaintiffs in this area, and particularly with respect to corporate accountability. The other thing that's interesting, or a few things that are interesting, you mentioned the aiding and abetting issue. The only entity that really argued for no aiding and abetting liability in this case was the Solicitor General's office in the Trump administration. And the court gave that no traction whatsoever. And I can't imagine that a Biden administration wouldn't go back to the old policy of the prior administrations in both the Kiobel and Gessner cases, that there should be corporate accountability and accepting aiding and abetting liability. So the real question is sort of what does this mean in terms of overcoming the presumption against extraterritoriality by alleging that there is aiding and abetting on US soil? And I think the other notable thing about this is that the court did not give very much traction at all to the categorical arguments that the defendants made about this issue. They argued that anytime the injuries take place outside the United States, anytime the underlying substantive violations like slavery take place outside the United States, that categorically you can't bring those cases. The court gave that no traction whatsoever. And so what they wound up doing is ruling against us in the narrowest possible way that they could rule against us, as I see it. That they looked at the allegations of a complaint that we were allowed by the Ninth Circuit to amend, and which we will amend. And they've said that the kind of allegations that we had, which were formulated before we knew we had to allege allegations about aiding and abetting conduct on US soil, because this case has gone on for a long time. They found those not to be sufficient, that the kind of general corporate activity or oversight that they found in the complaint was not enough to overcome the presumption. But they haven't said what other kinds of actions on US soil would be enough. For example, we said in our briefs, and some amici said, that what we're really talking about here is outsourcing a slavery supply system that's created and run by these big companies in the ways that Sean talked about, right? And so that's the theory that we're going to amend the complaint. It's not just general oversight. They created this system. They run this system. They're not passive recipients of cocoa beans. You know, they've created the circumstances in which this happens. They could end it. And everything they take to continue this supply chain being the way it is, enables this system of child slavery that's been so well described by Sean and Terry. And I think the big question after this is, what will they do with those allegations? What will the lower courts do with those allegations? How will this play out in the cases that still exist in the system? Doe versus Cisco, the Chiquita case, perhaps other cases. Will the lower courts read this in a way that allows us to bring these claims? And I think that the factual circumstances of many of the remaining cases, and there are only a few of them left at this point, make it possible to make compelling allegations that fall within the court's decision. And the other thing that I think is important is that only 3 justices want to read the Alien Tort Statute as basically being a relic of the past, which was the decision which was the argument that was rejected in Sosa versus Alvarez Machine 17 years ago. It's basically Judge Bork's decision in the Telloran case in 1984. I guess it goes back that far now. And there were 3 votes for that in Sosa. There are 3 votes for that now. They haven't gained a single vote in 17 years. And so there does not seem to be an appetite in the court to shut down the Alien Tort Statute. There's an appetite for narrowing it. There's a concern that perhaps Congress should get involved and give them more guidance about the kinds of cases that should be brought. But I think that the bottom line of this case is that plaintiffs in corporate accountability cases are still alive and kicking.
Well, that's good news, Paul. There's a lot of things that you identified there that I think I want to like dig in on a lot deeper. So let's I'm going to pick out those issues sort of one at a time. Going back to the aiding and abetting liability question, and maybe Beth, you can jump in here. So this is something that, can you give us, just sort of remind us, why was aiding and abetting liability on the table? What were the arguments that were being made? And what do you think it means that the court just totally ignored it?
Yeah, thanks everybody. Hi. So generally, when we're looking at alien tort statute cases, they fall into two buckets. The first bucket, and this was the original model, the famous Filartiga case coming out of New York, where it's an individual who's being sued under the alien tort statute. This is the individual torturer, the individual trafficker in this case, for example, or the individual war criminal. The Filartiga case involved a police chief who had tortured a young boy back in Paraguay, and then his family identified him living in New York. He'd overstayed his visa, and they originally sued him under the alien tort statute. The district court dismissed that case. The Second Circuit reinstated it. So that was the original model for a long time. Then that same court, the Second Circuit Court of Appeals, ruled that a non-state actor could be sued under the alien tort statute. And that really opened the door to these corporate cases, because we'd always conceptualized torture as a tort that required some form of state action or the acquiescence of a state actor. But by virtue of saying that you didn't have to be a state actor to be sued under the alien tort statute, that paved the way for these corporate cases. So plaintiffs' lawyers started bringing cases against corporations. And often the theory of liability is not necessarily that the corporate actors themselves, so for example, employees of the corporation or the principals or members of the board, are the ones who are committing the violation, but rather they're working in some sort of a partnership arrangement with local actors abroad. So in this case, you have big chocolate companies that are sourcing chocolate from plantation owners. It's the plantation owners that are engaged in a process of trafficking, slave labor, forced labor, child labor, et cetera. And the corporations are somehow complicit. Now, as Paul described, I think we're in many respects starting to rethink what these relationships look like. And they're less about being an accomplice to these acts and more about being in a sort of partnership where they're working under, I call it a joint criminal enterprise or call it a common scheme of some sort. But in any case, many of the early claims against corporations under the alien tort statute were brought under theories of what we call secondary liability. So you're not directly participating, but you are acting with the knowledge that some other entity, in this case, the plantation owners, are committing those abuses. You're aware of that, and you're providing substantial assistance to that conduct. So it's just like the guy that drives the getaway vehicle in the classic bank robbery, right? There's somebody that's doing the robbery in-house and somebody that's assisting that. They're all liable under the criminal law. And we sort of transported this theory into the alien tort context. And so the question of whether or not the alien tort statute supports aiding and abetting or complicity forms of liability has been sort of percolating around in the lower courts. But by my count, at least 6 circuit courts of appeal have all sort of said, either they've ruled explicitly or they've just sort of assumed that, of course, you could also sue the accomplice under the alien tort statute. It would be a very odd system of law indeed if you could only sue the direct perpetrator and not those who provide substantial assistance with the knowledge that they're doing so and that they're advancing violations of international law. And so that's where the law stood at the time. And Paul is exactly right that none of the defendant corporations in this case even raised the argument, I think because they felt it was such a non-issue and it was not going to be a winnable argument. They didn't want to waste space in their brief or their time at oral argument. But it was the Solicitor General under President Trump who, both at the stage at which they're trying to get the court to take the case, we call it certiorari, and then again, when it was rejected at that phase, then again at the merits phase, they tried to eject this issue back into the case. And it's quite significant because it would eliminate not just, if the government's argument prevailed, it would eliminate not just corporate complicity arguments, but even against individual defendants. And so it was a very wide sweeping set of arguments in the government's brief. Now, it actually got some airtime at oral arguments, and we've put some links in the chat to some discussion of the oral argument. But in the actual opinion itself, there's very little there. Alito sort of references it in his dissent that says, well, we're going to have to sort this out eventually. But the main opinions don't give it any airtime at all. And so as a result, we're left, the lower courts are left with the guidance that, these sorts of claims under an aiding and abetting theory or other forms of secondary liability are still available to plaintiffs, and they should be entertained by the lower courts.
Great. So what I'm hearing is on corporate liability, we have a win, and on aiding and abetting liability, we have a win, essentially. So that's really good news. These are the two issues that we saw before the court, and that seems super positive. So now I want to turn to extraterritoriality, where I think it's a little bit more complicated, but we'll see what you all think about this. So I want to go back to Terry. In addition to the sort of absence of any analysis of aiding and abetting liability in the decisions, I was really struck by the absence of the touch and concern language. So for folks that follow this line of cases, you know that the Kiobel case used this language about how a case needs to touch and concern the United States with sufficient force to displace the presumption against extraterritoriality, or the idea that a statute does not apply outside of the United States if the language of the statute or the legislative history does not so indicate. And so this language seemed like the test. This is sort of the Kiobel test, the touch and concern test. We have a whole ruling on extraterritoriality on an alien tort statute case, and this language is missing. Terry, what's going on here, and what's the test now?
Well, I think it's arguable that there was no ruling on what the test is, but Justice Thomas gave it pretty short shrift in that he appeared to be applying the two-step focus tests of RJR Nabisco, where you first decide if the statute is extraterritorial, and then if not, you have to decide if the focus of the claims is on concerns the United States, that the activities that are the focus of the complaint occurred in the territory of the United States. He starts off saying he's going to do that, and then he kind of reviews what the disputed issues were, and certainly one of them was, what is the test? And then before he announces that he's going to toss the complaint out, he says, well, even if we resolve all of the issues in plaintiff's favor, this complaint is still deficient. So I think that leaves a little room to argue, well, he didn't really say we did or did not satisfy the focus test or the touch and concern test. He basically said there's no test that we've ever considered for extraterritorial application that is satisfied by this particular complaint. And I must add, by the way, that he was very, very, let me say, very dishonest about his assessment of the allegations. We certainly alleged more than mere decision-making and mere corporate presence. We had lots of specific allegations about where the funding came from, what decisions were made, what assistance was provided, et cetera. And he just ignored those and generalized that we're only talking about operational decisions and tossed it. But going back to your question, I think it's likely that a future court, a lower court, will apply the focus test from Nabisco, because that is what Thomas appeared to be doing. But I think you certainly could argue that that has not been directly resolved.
So Paul, oh, okay, Sean, yeah, Nathan.
Oh, no, I'm sorry. I just wanted to jump in and say, for those non-lawyers listening and maybe having read this case and read the part that Terry was just referring to about not alleging sufficient facts, please understand, Terry has had zero opportunity for any discovery, any depositions, any day in court, any evidence, any jury, nothing. Why? Because the Nestle lawyers at $2,000 an hour for the last 16 years have prevented him from even engaging in any discovery or presenting any evidence before a court. Don't you think that if he'd had 16 years of depositions and discovery, that there might be other facts alleged? Yes. So I think it's important to remember for the lay people out there that, you know, this was all stopped at a motion to dismiss before it could ever even get started. I just wanted to mention that.
Yeah, and if I could add, thank you, Sean, you're absolutely right. And if we could add that we cited in our brief that it's normal, it's common practice that the Supreme Court says things like, we don't review allegations of complaints, that's below our pay grade, and they remand the case. Exactly what Alito wanted to do. For once in my life, I agree with everything Alito said, that normally you would send the case back and not even comment on the sufficiency of the pleadings. But they went out of their way, and I'm really curious what anyone thinks about how Kagan, Sotomayor, and Breyer joined in this opinion that really was unfair treatment of our allegations and ignored their normal process by actually weighing in on the allegations.
You know, I think this is a really important point, and Sean's point kind of gets to the idea of there being a lot of information that's within the defendant's control. And so lack of ability to get to just even the point of discovery and get that information from defendants when you're trying to show what they were doing in the United States is a real serious barrier. I'm going to switch my order a little bit and go to Beth now. Beth, I wonder if you can talk to us a little bit. So we talked about the sufficiency of the allegations, just to build off what Terry was saying. You know, the Kiobel decision talked a lot about mere corporate presence, which Paul was discussing earlier. And now they're using this slightly different language about general corporate activity, which seems to include decision-making. So that, to me, that general corporate activity language really jumped out at me. What does that mean? And how does that impact the way that extraterritoriality is going to be understood in cases going forward? And are the lower courts even going to know what to do with that?
Yeah, I agree. It's a very short opinion. So even if you haven't read it, don't be daunted by it. It's actually quite short. It's only just for Supreme Court opinions, it's quite short, I think. And actually, it's interesting. Be very careful when you read the opinion, because it's only parts 1 and 2 of Thomas's opinion that are actually the holding. He goes then spends another 8 pages in part 3, which is sort of his theory about why some of the early precedent should be overturned and we should essentially jettison the ATS altogether. That's just his personal musings that only garners 2 other justices. So when you do read the opinion, it's really only parts 1 and 2, which are 4 pages long. So that's what I'm saying. It's not a big opinion. So to answer your question, there's not a ton of guidance, honestly, that the lower courts have been given here. What I think that at least Thomas and I think the 3 more left-leaning justices do want to see is more specific conduct alleged that is tortious in and of itself. In other words, not just we're doing business, we're having arrangements, we're having supplier arrangements, we're doing marketing, et cetera, in the United States, but actually conduct that gives rise to tort liability happening in the United States. I think we're going to find that, and I think it's going to take some very good investigative work and perhaps some insiders who are willing to come forward and work with plaintiffs' counsel and reveal what they know about how the decision making is made, such that this is in fact a system that is benefiting from child labor and benefiting from human trafficking, because it's all part of the business model essentially. And so much of that is going to be developed back at headquarters, which happens in this case to be in California when it comes to Nestle, for example. So I think we have to show more conduct that is closer to the harmful conduct that is being alleged in these complaints, rather than kind of general business activity that's happening in the US that then has some sort of a loose connection to what's happening where the harms are occurring, which is generally in these cases abroad. We've got some corporate cases that are pending now where it's very clearly going to be easily satisfied. And I think others it's going to be trickier. And this gets to the point that, that Sean and Terry were making, is that so much of this depends on the ability to do discovery with respect to these corporations, because they control all of that information. And so we're going to have to just do a much better job of doing investigative work in advance so that we can put these types of allegations into these complaints. And over the years, the reality is that the Supreme Court and then now the lower courts have raised the bar on what is required at early stages of pleading. So what has to go in the complaint? It used to be we had what was called notice pleading, that all it was required is that we put the defendants on notice as to the nature of the allegations against them. And now they're just raising the bar. And so that pushes upstream the kind of investigative work we have to do. And so now what Terry and Paul have to do is go back, get leave to amend their complaint, and try and put in more allegations that show that decisions that were being made, arrangements that were being organized, et cetera, that were directly related to the trafficking and the abuses in Cote d'Ivoire have a link back to the management sitting in California and wherever the I forget where Cargill's located, Pennsylvania maybe, that there's that really tight nexus to the United States.
That's really helpful. So what this makes me think about is the Chiquita case. And I say this because this is a case where, for probably a lot of folks listening are familiar with this case, but this is a case where the allegations are that Chiquita, in their boardrooms in the United States, made decisions to finance paramilitaries in Colombia, even though at the time they knew that the paramilitaries were carrying out extraordinary human rights violations. That at one point the paramilitaries had been designated a terrorist organization and they continued financing. They had to pay a $25 million fine to the Department of Justice for doing this. So it's really well established that they made the decision to do this thing in the United States at the highest level of the organization. And that case was dismissed under Kiobel at the 11th Circuit, right, on the touch and concern test. That seems like the sort of facts that to me, should have passed touch and concern in the way that I read that case. So first I felt like the 11th Circuit screwed up there, but now that it seems like the bar is even a little higher. What kind of case, like what kind of facts are actually going to get through this? If Chiquita couldn't pass touch and concern, how are we going to pass the more than general corporate activity step 2 RJR Nabisco test, whatever it is, if we can even figure out what it is? What do you think would be sufficient? And I'll say Paul or Terry, since you're both represent plaintiffs in the Chiquita case. So you might have some point of reference there.
I think one of the things to, and particularly for the non-lawyers in this, is that there's a certain amount of irrationality in the legal system that one, if one is in it for long enough, you realize that there are decisions that simply can't be squared with the facts. Right? Chiquita is one of those. I argued that case in the 11th Circuit, and we had a panel that included a judge from the DC Circuit, Judge Sentel, who from the beginning has thought that the Alien Tort Statute should not be used in any modern context whatsoever. We had a dissenting opinion that laid out all the reasons why the allegations that we made touch and concern the United States, because they obviously did. Right. I mean, there's a criminal prosecution, a criminal fine. The United States government established that, but we had a panel that just wouldn't accept that. Right. And unfortunately, the 11th Circuit didn't take it en banc, and the Supreme Court didn't take it. So I would think that Chiquita would be exactly the model that would fit after Nestle versus Doe. But it didn't in that case. And that's something, you know, we are the to go back to another issue, the motion for discovery. I mean, and we made a motion for discovery in Nestle. We've sought discovery. We've tried to fight that out, but we have a district judge that really doesn't like our case. I think that should be obvious by the fact that he dismisses it on whatever grounds he can find. And, you know, if you're stuck with a judge that doesn't like your case and has a different ideological perspective on these matters, they're not going to give you discovery, and they're not going to let you make your case. And on the other hand, we've had some other cases where we have lots of discovery. And, you know, I think one of the things we're going to have to think about, and Beth mentioned this in terms of investigation, but there are also some other strategies that we may use. For example, Terry's got a new case against the chocolate companies under the Trafficking Victim Protection Act. If he gets to discovery on that, that discovery may be relevant for Alien Tort Statute cases. We have a case that's pending in Houston having to do with trafficking, labor trafficking to US military bases during the Iraq War. Well, we've got lots of discovery in that case. If we bring in Doe versus Chiquita, there's been tons of discovery under the Colombian law claims, and Doe versus Exxon, tons of discovery about Indonesia law claims, which enable you to get the information that you need to bring either to resurrect an Alien Tort Statute claim or to bring a new one based on the things that you find. I think we're going to have to use every tool we possibly can to unlock the discovery that we need to get this information. And I think at some point, I hope the courts will decide that we're entitled to some discovery, that as long as you have plausible allegations that get you to aiding and abetting on US territory that satisfies Nestle, you should be able to get at least some discovery. And I think Beth is right that we're facing, it's not just this area. I mean, I think we're facing a court that has tried to limit access to the courts in a whole variety of areas, particularly involving corporate liability. So this is not the only area where cases like Twombly and Iqbal, which are the cases that make it hard to get past the pleading stage, you know, we have to fight that in this area as people are fighting in other areas. But I think we have strategies to do that. I think there'll be ways to do that. I think Congress could have hearings, for example, to open up some of these issues, and we could use what they come up with. I think we just have to be even more creative, perhaps, than we've tried to be in the past to get past these obstacles, because I think there's some, if they accept that aiding and abetting on US territory is actionable and gets you past the presumption against extraterritoriality, there are cases that can be brought. And I think we need to bring them.
So then maybe Terry, can you speak a little bit to, in this particular case, when you all amend the complaint to comply with this decision, what kinds of allegations do you think you're going to be able to make that might reach this level? If you could
Well,
speak.
yes. First of all, we're going to have a lot more about the child labor issue itself. That there's no question that these companies, Nestle and Cargill, and then all of the others as well, when they sat down in 2001 and derailed a real law and came up with the voluntary Harkin-Engel protocol, where they promised in 2001 to stop using child labor. I think there's a whole lot of ammunition there about what they decided, what they then did or didn't do to solve the child labor problem in 2001. The fact that it still exists and it's getting worse indicates that they made some decisions that not only didn't solve the problem that they promised to solve, but they continued to profit from child slavery, and the problem got worse. I think we just also need to be way more specific. When we say they funded the operations, well, what did they fund? They funded farmers that are using slaves, and I think we need to draw that out a bit more. And we need to put a few more Cargill and Nestle staff on the ground that were sent from the United States that either facilitated the ongoing use of child slavery or that turned a very intentional blind eye towards what they observed. Because as you too, Charity, have seen with your own eyes, if you go out there and go on some plantations, there's no way you're not going to see children. And if you ask, you're going to find out a lot of them are trafficked. So I think that those are the kinds of details we need to draw. As Paul mentioned, we've never had a chance to do that yet. And our original allegations, I think, were perfectly terrific and should have been enough, but they're not. So I think we can beef them up significantly. I also wanted to add to what Paul said about the Chiquita case, that this Judge Santel is particularly horrible, and everyone knows his reputation. But I argued the Drummond case after that in the 11th Circuit, and we had a really good panel. And they almost, they basically apologized that they're stuck with Chiquita, that it was a law of the circuit, and they were sort of inviting me to distinguish Drummond from Chiquita, but I couldn't, because they're exactly the same. The decisions were made in the US to fund a terrorist organization in Colombia, and the money came from here, all of those things. But I lost simply because of the precedent. So I do think that it's luck of the draw with these panels. And if you're not in the 11th Circuit and you have another case like that, I think you ought to get past a motion to dismiss at least.
Right. I think that's a big problem that is probably going to continue to plague this area of law. I have a few other issues I want to hit on quickly. I know we've got some really good questions coming into the Q&A. So maybe if we could do sort of brief answers just to make sure that all of the issues that are on the table. Beth, earlier you mentioned kind of insiders. I've heard some folks say that in response to this opinion, they're sort of pushing us in the direction of almost needing a whistleblower, someone inside of the company who can provide that kind of information before you would get to discovery. Do you feel like we're moving toward a whistleblower model, or is that sort of overblowing this decision?
No, I don't want to overstate it. And I think Paul and Terry have both mentioned this, that we just need to be more creative. We need to look for these other sources of information. And one more that I would just add is activist shareholders, right, who have access to the board meetings, who can request information. We should be doing more congressional hearings. We have a question in the Q&A about this, where Congress can say, we want to understand how US corporations are benefiting from child labor and child slavery in West Africa. They can hold a hearing on that and force the corporate principals to come and to defend their action. And they can ask for information. They can ask for data. We have a lot of academics doing really important work. We've put some of those links in the chat, who are really looking at the direct impact of these corporate decisions on workers in these foreign jurisdictions. And so I think whistleblowers obviously are going to be incredibly helpful. And I would hope that people would be moved, former employees would be moved by their consciences if they're aware of these sort of decisions being made at the highest of levels and are willing to come forward and to share that information. But I think we can also get that information through other means, and we just have to be more creative about that.
Great, thank you. Paul, I wanted to ask you quickly,
I
you
think
know, this
Sean
wasn't,
had a point.
Sean, I'm sorry, Sean, jump in.
I'm sorry. No, I just wanted to jump in and say, in terms of investigation and extraterritoriality, both. Remember, the Food Safety Modernization Act regulates all of these companies in foreign soil. So I would make a FOIA request to the FDA asking for specific communications regarding Nestle's foreign supplier verification program. These are on the ground in country. It's called an FSVP. Every company must have a foreign supplier verification program according to the Food Safety Modernization Act. They are absolutely regulated by the FDA on foreign soil before they can bring this commodity into the United States. So it's possible that some FOIA requests would yield some data. And I also think it's an example. We already have a regulatory scheme in place that is regulating these defendants, including me, on foreign soil. And anyway, I just wanted to mention that as a possible alternative.
I love that. Thanks, Sean. Appreciate that. Paul, I just wanted to jump to, there was this discussion, maybe like almost like the most fireworks that there were in this decision was about the SOSA standard and these sort of 3 historical torts. This isn't in the majority opinion, so in terms of precedent, it doesn't make any difference. Can you just tell us a little bit about what is sort of the dispute going on between part 3 of Thomas's decision and Sotomayor, Breyer, and Kagan's opinion?
Yeah, I mean, I think that there's a case that was decided in 1984, Teleran versus Libyan Arab Republic, and there were 3 opinions in that decision in the DC Circuit. Judge Bork wrote a decision which is basically Section 3 of Thomas's decision, that the Alien Tort Statute, because it was created in 1789, if it applies at all, it only applies to the norms that Blackstone recognized at the time that we became a country, and that would include piracy, attacks on ambassadors, breaches of neutrality, that kind of thing, and that it really had no contemporary significance. Judge Edwards in that decision basically accepted the Filartiga decision and the idea that the Alien Tort Statute had a modern application, that any time that you could, a non-citizen had a claim for a tort committed in violation of the law of nations or treaties of the United States, that could be brought. What Sosa versus Alvarez-Machine did was basically resolve that issue. And it resolved it by deciding that the Alien Tort Statute in fact had contemporary significance, and that federal courts had retained the ability to recognize causes of action for at least certain law of nations violations. And they created what's been called the historical paradigm test. And basically what that means is that if you have a claim, like our claim for child slavery in this case, that has the same kind of widespread acceptance and specificity as the claims that Blackstone would have recognized in 1789, that those could be actionable under the Alien Tort Statute. And so, for example, in this case, no one attacked the idea that you could bring a claim for child slavery after Sosa. I mean, it's clear that you can't. It's not Justice Thomas's Section 3 would say you couldn't, and would take us back to 1789. But only 3 justices agreed with that. And even Justice Gorsuch didn't really agree with the Thomas view of that. I think his view is that Congress really ought to decide these issues. And I think that's been, I think that the 3 that would limit the ATS have one or the other of those positions, either that it's a historical view that it really never left 1789 until Congress actually establishes the cause of action. But 6 justices didn't go along with that, right? And I think significantly, the defendants, not only in this case, but in Kiobel and Jessner, the other cases in front of the court, have strenuously argued with the, sorry about that, with the SOSA premise, right? And have asked the court essentially to gut SOSA, and that's been rejected.
Beth, do you want to jump in here?
Yeah, just to raise two quick points about this historical paradigm model. One is that one of the three historical paradigm torts that it's widely believed by pretty much everyone who's done historical research here that the ATS was supposed to address was piracy. That was one of the primary international law violations, one of the first to be formed. And piracy by definition, and even up till today, happens on the high seas. It's generally outside of any particular state's jurisdiction. So that's really in great tension with this thrust towards extraterritoriality. I mean, you know, if we could go back in time and argue this again, I think we could make more of the fact that if everyone agrees that piracy was supposed to be actionable under the Alien Tort Statute, piracy inevitably happens outside of the United States. Ergo, Congress assumed that the Alien Tort Statute would support extraterritorial torts against conduct that happen extraterritorially. You know, that inconsistency exists and we're sort of stuck with it now. The second thing that I would raise is there's also a conversation happening amongst the justices about the separation of powers, where the skeptics toward the ATS seem to say, oh, this is for Congress. We can't infringe upon Congress. It's not for us to invent causes of action. And Sotomayor, in her really brilliant opinion, and she said this before, says, wait a minute, Congress told us that we are to provide federal jurisdiction over individuals who commit torts in violation of the law of nations. Congress did not define torts. Ergo, it is for the courts to figure out what constitute torts in violation of the laws of nations. And this is then what we should be looking at is modern international law to determine whether or not torts of torture, crimes against humanity, genocide, trafficking, all of the things we can now prosecute at the international level and at the domestic level as international crimes, whether or not those are specific enough, whether they've been established clearly, whether their elements are clear, whether they're universally prohibited, and if so, we should treat those as modern day acts of piracy. And therefore, we should allow the Alien Tort Statute to provide a basis for federal jurisdiction. And so in her view, the courts are actually evading their congressionally given responsibility by not doing what SOSA implied that they should do, which is to look at modern international law and figure out what the equivalent of piracy is today, and to do what Congress asked them to do, which is to provide a federal forum for victims, including aliens in this case, who happen to be the victims of those international law violations.
Great, thanks, Beth. It is hard to imagine the pirate who's out there committing crimes on the high seas who would meet this test, who would have sufficient connection to the United States to meet the test, when that's one of the three historical torts. It's a really interesting conflict there. I want to get to what we think Congress should do, and I want to kind of start with Sean on this, but before then, there's a lot of folks I think want to know kind of what else can be done for plaintiffs like this. And so I want to kick it over to Terry. I know we've mentioned you have this TVPRA, this trafficking statute case that you've brought, and then International Rights Advocates and Corporate Accountability Lab are also working together on petitions to Customs and Border Protection under Section 307, and we're planning to file a supplemental petition to prior information that we have given to CBP tomorrow. So that's exciting. Terry, can you speak a little bit to what can we do if this is going to be so difficult for potential plaintiffs in this industry? What can we do to make the industry better?
Thanks. Well, first I want to just quickly jump on Beth's point that what we need to do is find a pirate and get the pirate to commit a crime and then bring that case. We got to find a pirate case and see what they say about that. Yeah, sort of the good news, good old Justice Thomas in his justification for trying to shut down the Alien Tort Statute commented that a good example of Congress doing its job with specificity is the Trafficking Victims Protection Act. And thankfully, as a backup plan last February, we filed a very thorough, comprehensive trafficking case against not only Nestle and Cargill, but added Mars, Hershey, Mondelez, Berry Callebaut, and Olam, pretty much all of the big chocolate companies. And the kinds of information we now have about their activities and their supply chains and so on went into that complaint. And I feel it's almost a no-brainer that we have satisfied the simple elements of the trafficking statute, and that there's very little for the companies to say in the way of don't interpret the statute the way that they're advocating, because we're going by the letter of the law. Just briefly, the elements for a trafficking case is that you have to show that the companies knew or should have known that they're participating in a venture that uses trafficked or forced labor. Doesn't even have to be child labor. And we've easily met those elements. The cocoa companies in particular, they formed a couple of associations, but the most important one is the World Cocoa Foundation. All of the big companies are members, all of the small companies are members. But from that entity, they're crafting their schemes to try to avoid scrutiny of their child slavery and make decisions about how they're going to present their faulty, fake, bogus programs that are not doing anything about child labor. So I think it's a very solid case, and I do hope we get discovery fairly soon. And then, yes, as you mentioned, we have an excellent petition already pending that we filed, what was it, February 14th of 2020, that Customs and Border Protection have been sitting on. So Charity and Allie did a very, very thorough amendment that's going in tomorrow, just really to remind the customs people that they haven't done a thing for all of this time on a petition that is a no-brainer. Everyone agrees that there's cocoa coming into the country with forced labor, and that would require them to ban the importation of that cocoa. So those are two things we're doing, and we're going to amend the ATS case, and if for any reason the court doesn't allow that, we'll appeal that, but we could also file a new ATS case with new plaintiffs, because unfortunately they just keep coming. There's no shortage of plaintiffs who are former child slaves, but the message we keep giving on social media and any other forum that we can possibly use is that as long as we're breathing air, we're going to continue to go after these cocoa companies until they stop enslaving children. Now, every time I say that, I get a little nervous because we've been doing this for like 20 years, but there's no end in sight for us anyways. We're going to keep pressing until we get a victory and stop this practice. That the amazing thing to me that I just can't figure out how they're getting away with it is that the companies admitted in 2001 when they signed the Harkin-Engel protocol, within the text of that protocol, they admit that they're using the worst forms of child labor to harvest their cocoa, and that they promised to stop it. For those who aren't following this, they've since given themselves 4 extensions of time. They were supposed to end it in 2005. That's when we sued them, when they gave themselves their first extension of time. I said, all right, we gave them a chance. They didn't even do anything. But they've now given a new extension of time so that by the year 2025, they're promising they'll reduce their use of child labor by 70%. So that's really evil genius if you think about it. They've gotten permission to keep doing this until they stop. And so many people, particularly members of Congress, appear to have accepted that. And as time goes on, I think that outrageousness just keeps increasing, and we've got to figure out some new creative ways for Congress too. People have mentioned, well, Congress could have hearings. Well, we've been bugging them for 15 years to hold a hearing. I wanted to see the executives of the cocoa companies frog marched out there like they did to the cigarette companies and make them testify under oath about why they haven't stopped yet. I think that'd get their attention, and that ought to be something we really do focus on. I will stop there.
Thanks, Terry. Okay, so we want to do a quick round here on what Congress should do, if anything. You know, Sean, what your brief argued for was that there should be corporate liability for this kind of international child trafficking case in the cocoa sector. Seems like there still is. Does Congress need to do anything? Are we good?
Well, I mean, I would echo what Terry said. It would be great if Congress would have just even hold hearings. But I think more than that, if I could just divert a minute and say, let's please not forget that the TVPRA has criminal liability as well. The standard of proof for criminal liability is that the defendant knowingly benefited financially. Let me just say, as a former criminal defense lawyer, that is a very, very low standard of proof. Meaning, I think we have a good case to make that these defendants need to be having $2,000 an hour discussions with their lawyers about what the federal sentencing guidelines look like. That's what I want to see. And when these lawyers when these executives from Nestle and others pucker over corporate criminal liability, then I think we'll see a lot of quick resolutions to this. And when I read what the standard was, I was actually shocked, because if just one of these companies is indicted, and let me also just say, whether it's the CBP case, the TVPRA, Alien Tort Statute, whatever it may be, for the industry, for Big Chocolate, what we're looking at is we just need one nick. There just needs to be one nick on one of these defendants, and the house of cards will fall, because they can't, it'll be almost like Prop 65 in California, and which has, we can have a whole other hour discussion about that. But what I want to say is that the industry they won't be able to withstand it. Once the spigot has turned on to even a drip of success, then the floodgates will come, and we will see an elimination of this problem. And I just think one of the avenues would be not necessarily more laws, although, I think it would be great perhaps if they amended the TVPRA to include the kind of questions that we've been talking about here. Perhaps they can address the question and create additional statutory causes of action, so you don't have to worry about whether or not there's a, quote, private cause of action under the Alien Tort Statute, and address this question of territoriality statutorily. But hey, Congress, we can't get Congress to agree on anything. I'm so depressed about that I don't hold out much hope. But I do think there's a lot of hope for the present litigation that's pending right now. I remain optimistic about this.
Yeah, I think that's a really good point, Sean. The TVPRA does have this criminal provision that if prosecutors would just act on it, we would have something on the books already, and maybe we don't have to rely on a Congress. It's very difficult to move things through. But the fact that prosecutors haven't done that, I think is telling. So maybe if we could go to Beth next, what about civil liability? Is there something that Congress should do here to increase opportunities for these types of plaintiffs to bring cases?
Yeah, and I agree. It's hard to get Congress to produce law. So, this may be a long shot, but I think a very simple fix to the Alien Tort Statute, and I'm not sure it actually would even require amending the statute itself, other than some sort of resolution expressing the understanding of Congress. And I sort of defer to Paul and others as to whether or not they think this would work, but basically just making clear that they assume that the ATS would apply to extraterritorial conduct, and invoking that deep history, tracing back to the time of the founding, when of course piracy was one of the primary allegations that it was expected would be brought under the Alien Tort Statute. So that would be one area, just making it very clear that Congress expects the statute to apply to acts that happen extraterritorially. The second thing we can think about is looking at the Torture Victim Protection Act, which was passed following this Taloran case that Paul mentioned, to provide an unassailable cause of action for acts of torture and extrajudicial killing under international law. And so if you have those two claims, you can use the TVPA. You don't need to use the ATS. The TVPA is very expressly extraterritorial, but it only is open to those two claims. And so if you want to bring other claims like war crimes or crimes against humanity or genocide or trafficking, you have to use a different statute. So one thought would be to amend the TVPA and to add new causes of action there. Now, one hitch with that, it wouldn't solve the problem we have here, because the Supreme Court in another earlier case determined that the TVPA only allows for jurisdiction over natural persons. And so you can't sue corporations under the TVPA. So that would require a second fix in addition to adding causes of action to make clear that corporations can be sued. And Congress could do that, and they could set whatever standards they wanted, and they could raise the bar if they wanted to make it more difficult to do so. And provide some guidance to the courts, so that it's not the courts essentially making up these standards and it's all about which panel you happen to draw on the 11th Circuit, but rather some congressional guidance. They could hold hearings, they could hear testimony from practitioners, from corporate principals, et cetera, to come up with a sort of system that works. So those are two areas. The TVPRA is quite a robust statute. It might provide a good model for thinking about how the ATS and the TVPA could be updated to sort of match that. We also have a civil statute for acts of terrorism. And so that's also available for civil plaintiffs, and kind of harmonizing and rationalizing those civil claims could be really helpful. We had a question in the chat I'll just bring to everyone's attention about whether or not any of this impacts the ability of the United States to bring criminal charges. And the answer to that is no. We have a federal penal code that has a number of international crimes mentioned that expressly applies to extraterritorial conduct. And all that matters is that the defendant, the perpetrator, is present here in the United States. And so as long as they can be found here, they can have criminal charges be brought against them, even if everything, all the victims, all the relevant conduct, all that happened abroad. And so I think we should be moving our civil system towards more of a model that's in parallel with our criminal law system.
Great,
I
thanks,
have a
Beth.
couple of
Paul, do you
things,
wanna jump in?
Charity. Sorry.
Go ahead.
The one thing is that on the Torture Victim Protection Act, in Chiquita and a couple of other cases, we've sued individual corporate actors. And the prior decision that prevents you from suing the corporations does not prevent you from suing the individuals, the managers, the chair of the board, things like that. And I know that Sean mentioned how that might change. It might change if people were brought up on criminal charges. It may also change if corporate executives think that they're going to get sued under the Torture Victim Protection Act, because that is explicitly extraterritorial. And I would echo what Beth said about the extraterritoriality fix, if you will, on the ATS. I think if a modern Congress passed a law that said that the ATS was explicitly extraterritorial, it would not only solve that problem, it would be an enormous piece of evidence that the Congress likes the ATS, thinks that it should exist, thinks that SOSA is the right thing. And it would answer a lot of the justices who say that Congress should decide, because Congress would have given a clear signal that they want the Alien Tort Statute to be used extraterritorially and otherwise.
Carrie, shoot.
Just for everyone's information, the idea of using the criminal law, it's great, but of course that too depends on some arbitrary decisions by prosecutors. In the Chiquita case, Chiquita was prosecuted criminally for financing a terrorist organization. That came about because a board member for several years in a row appeared at the board meetings and said, we can't keep funding the AUC, they're a terrorist organization. And the rest of them told him to shut up. And this is the most profitable operation we have in Colombia. And they kept doing it. So at some point, this guy shows up at justice with a box full of documents to prove that Chiquita was financing the AUC. Even then, the Justice Department sat on it for a year, and this guy raised his voice again and said, are you going to do something about this? So they finally did. When they did, I have the Drummond cases that are exactly the same. Drummond financing the AUC that murdered hundreds or thousands of people in Colombia. I spent years talking to different prosecutors saying, what, this is the same thing. Why don't you prosecute Drummond? They never did. Administrations changed. People didn't view it as a priority. I think there's a across the board bias against doing something to hurt American business. And you really have a high bar to get them to do that. I am having discussions. I'm bothering the hell out of the Justice Department right now about going after these cocoa companies on that standard that Sean pointed out is a very easy standard. I've yet to get a serious nibble like, okay, we're going to do it. But people seem interested, I'll say, but that does not yet translate into a prosecution. But I agree completely with Sean that we get one company prosecuted and the others are going to change overnight. And so it's worth putting the time into. And the same thing is true of the tariff statute that you and I have used, Charity. It depends on a government bureaucrat taking action, and that's very difficult to complain about. We're being polite with them, like, well, what's going on? But we can't make them act, and so far they haven't. I have an idea for amending the Tariff Act that makes it parallel to the EEOC Title VII statutes, that after you file your petition, if they don't take action within a certain amount of time, like 180 days, that you have a private right of action then to file the case in court on behalf of the victims of the forced labor or trafficking activity. But again, getting Congress to amend anything is going to be hard. But we have good ideas. We just need political will and cooperation of the administrations.
Great, thanks, Terry. So we want to get to the Q&A here. We only have 15 minutes, and I want to address as many of these as we can. So maybe if our panelists can try to be brief as you respond to these, we don't all need to respond to all of them. The first, I'm going to take two of them together initially. So we have two questions that are related to taking legal actions outside of the United States. So I wanted to group those. One is from Morgan Roddy. Morgan, she doesn't say this, but she runs a little chocolatier called Queer Chocolatier in Muncie, Indiana. And she asks, have the governments of Mali and Burkina Faso taken any legal actions? And do the parents of the trafficked children have any legal recourse? So I think that she's, imagining, it's kids from Mali and Burkina Faso that are being trafficked into Cote d'Ivoire. So those governments have an interest and those parents have an interest. Has there been any local legal action by any of those actors in West Africa? I don't know if Terry knows the answer to this.
Short answer, no. In fact, my lawyer contact partner in Mali, who works with us on all of these cases, he was the counsel general to the Malian embassy in Cote d'Ivoire, and he was aware of the trafficking problems, and he started getting involved, and he actually rescued kids. The Cote d'Ivoirean government complained to the Malian ambassador, who told Mako to knock it off. It was creating hostilities between the countries, and he continued to do this work, and he was fired from his position. These governments are extremely corrupt, and most of the high government officials in Cote d'Ivoire are getting rich off of the cocoa industry. They're taking bribes, they have ownership interests. So it is true that there are rights there, that the governments have an interest in protecting their citizens, and that the parents should have some rights as well, but they don't have a forum. And in our case, Paul and I, the ATS case, sometimes you face a foreign non-convenience allegation by the defendants that the case should be moved to the location where it occurred. We have pleadings in our complaint to the effect that we would not have a forum in Cote d'Ivoire or anywhere else in that region because of corruption and lack of effective courts and so on. And the companies have never even bothered to challenge that because it really would be a pretty easy case to make. So unfortunately, it adds to our pressure that I think we really are their only hope for justice to take some action here. And notably in the Supreme Court case, the defendants kept trying to raise a foreign relations crisis to be able to say that that's why the case should be dismissed. That's a SOSA factor, that if it creates some kind of tensions with a foreign government, that the case shouldn't go forward. None of the governments involved expressed any concern whatsoever about this case. They probably are not even paying attention, but they've certainly not expressed an interest to help the people or to try to interfere in our case in any way because they're taking their own actions.
Great. I think that probably also answers a question by Greg from Wellspring, who's asking about the foreign legal assistance statute, which allows if there's a legal process outside of the United States, this is a discovery statute that allows you to get evidence from within the US to support that foreign legal proceeding. So he's asking if people are trying to bring cases in the countries where abuses occur and then use the foreign legal assistance statute to get documents and evidence in the US that you could then use to bring a US case. Oh, I'm actually was reading that wrong. So actually he's wondering if we could use the FLA to get evidence from the US for a foreign proceeding, but ultimately use that back in the US since we don't have access to discovery until later. That's a really
The
interesting
answer is
question.
yes. The answer is yes. And it doesn't have to be an existing case either. You can get discovery in this country under that statute, even for a proposed case.
So do you think that that's something that is going to happen, where there could be completion of litigation in Cote d'Ivoire and then an FLA case filed in the US to get information that could then be used to support these domestic cases?
We haven't actually used it in our case, but I think we should think about it. Marco Simons and the folks at Earthrights have really pioneered using the statute, and they've brought several cases in support of other proceedings. For example, they brought one after Kiobel to assist the Kiobel plaintiffs, who then went over to the Netherlands and filed an action there, which is another thing to mention, that there are cases that are pending in many other countries, in the UK and Netherlands. And it could be that we can get some information from those cases also for us. But, you know, hopefully this is a worldwide movement. That's always been, I think those of us that have been involved in this since Philartica have always hoped that this litigation would not only be in the United States, but that there would be a movement of people around the world that would take similar actions and make sure that you couldn't hide anywhere from justice. And I think that's still very important. And I think some major strides have been made in other countries, in some ways, you know, more important strides than some of the fights that we've had lately.
Just to echo that, Paul's point, it's really important. The European courts and activists and lawyers have sort of started to do their own brand of this litigation under their particular legal frameworks. And so we're seeing some really interesting, both criminal and civil cases proceeding in European courts against corporations and corporate actors, individual members. So there's the Lundin case that's happening in Sweden. There's the Lafarge case in France. So it really is sort of a kind of a movement now. And unfortunately, you know, there weren't many of those cases in the early days. And so it looked like what the US was doing was entirely unique and different, and we were somehow some kind of legal outlier. But now I think with these other legal systems showing that there's more consistency, there's much more of a movement. And I think that will help make US courts feel more comfortable ultimately entertaining these cases, because they're not, it doesn't feel like they're sort of out there on a limb, that in fact it's part of a worldwide movement.
I think that had an impact even in this case. The Center for Constitutional Rights and some others have filed briefs in this case and other cases that have pointed out these developments and made it really hard for justices opposed to the ATS to say that we're unique anymore, because we're not. I think there are cases like this in many legal systems.
And arguably, if your defendant is in the UK or maybe even Canada, your odds might be significantly better. We just see loss after loss, and I feel like Lee Day in the UK just can't stop winning. Those people are on fire. I have a couple other questions that we're going to try to get to before we're done here. Sean, I want to go back to you. So you talked earlier, we have a question about how traceability might not be as important if we can just focus on paying workers more, and that the price is really a big determining factor. So just to give us a sense, do you think that it is more important to dedicate efforts to tracing and that kind of data, or to campaigning for increased wages?
I think they're interrelated. What I'm saying is, and maybe I should clarify, I'm not saying that traceability isn't important. I mean, we can pretty much trace every single bean that we've purchased for the last 15 years from all of those origins that I mentioned. And it's very important to us, and we publish it on our website. And as I've mentioned before, you know, we not only trace this, we have a profit share program where we go back every year and give money to the farmers. We translate our financials into their language so they can understand how we calculate the profit share that we give them. But so I think traceability is important for a number of reasons. I mean, it's important for environmental reasons, it's important for regulatory reasons, it's important for blockchain reasons, there's all kinds. But what I'm saying is, with respect to this issue of child slavery, I think if we, you know, Nestle wants to talk about how challenging it is to have this problem of traceability. And what I'm suggesting is that Nestle needs to focus more money, like less legal fees, less PR, less social washing, less appeasement, and focus those resource dollars on paying farmers more money. And even I know that there are very sophisticated remediation and tracing programs in place, you know, that these companies have used, as Terry said, you know, to move the goalposts for the last 20 years. But what I'm saying is, if we move some of those resources to just paying the farmers more money, just pay the farmers more money, and some would say, well, look what Hershey did when we tried to, when Hershey was essentially being forced to pay a living income differential, and they said they weren't. And Hershey, that wasn't even in the news. I can't believe that. And the reason it wasn't in the news is because we had so much other stuff going on around the world, like a pandemic and everything else. And Hershey was literally able to get away with telling the Ghanaian government that they weren't going to pay a living income differential, and they ended up negotiating with them on this. This is ridiculous. But what I'm saying is, let's go back to that study, which says even a 2.8% premium, that's nothing. A 2.8% premium would eliminate the worst forms of child labor. So what I'm saying is, yes, tracing is important, but remove the argument of the defendants in this case that traceability is their obstacle, and say to the defendants and Big Chocolate, Barry Callebaut, Nestle, Mondelez, all these people, look, just pay them more money. I mean, unless they can refute this study, and which, I mean, I've not seen anybody come out and say that this economic model is somehow faulty. So I hope that clarifies what I was trying to say. I do think traceability is important. What I'm saying is specifically to the issue of child labor, pay the farmers more money.
Great, thanks, Sean. I think it's a really important point. Beth, I wonder if quickly, we talked a bit about, there's a question here about going back to touch and concern, and whether the ruling formally establishes the RJR Nabisco test as the framework for extraterritorial jurisdiction. We talked about that, but I wonder, Beth, could you maybe just help us really clarify? And maybe there's not a clear answer, but best you can quickly.
Yeah, and I'd love to hear from others, because I'm left confused as well. So the way the law had developed was we had a number of different tests that emerged in different contexts. So in the securities regulation context, in the Alien Tort Statute context, as to how to determine how to deal with a statute that didn't clearly apply extraterritorially, but you had to determine whether or not the particular act in question overcame this presumption. And we had this RJR Nabisco test that we mentioned, which was the so-called focus test. And then in Kiobel, the court developed this touch and concern test. And it was actually a great little test in a way, because it did eliminate the so-called foreign cube cases. We call these cases foreign cube because the defendant was overseas and foreign, the plaintiffs overseas forum, and the conduct in question. So it was pretty clear that unless there were a special set of facts that overcame that those cases probably would not survive under Kiobel, this so-called touch and concern test. But any other case that had any kind of a nexus to the United States, including, for example, the presence of a defendant, which can be quite destabilizing here. And Justice Breyer spoke in his, I can't remember if it was a concurrence or a dissent, but I think it was a concurrence, about how the United States should not be providing safe haven for perpetrators who are here. And so a case in which the defendant was present would significantly touch and concern the US, such that it should overcome the presumption against extraterritoriality, and that case should go forward. So the entire claim was evaluated under the touch and concern test. What makes me nervous about Nestle is there's no mention of that test at all. And in fact, instead, all of the justices that join the majority opinion seem to be adopting the RJR test, which focuses much more on the focus of the statute. And the theory is that the focus of the ATS is on tortious conduct, conduct that itself breaches international law. And that's why you need to show much more domestic conduct. I don't know if others think that the court has essentially overturned the touch and concern. The others on the panel think that the court has essentially overturn the touch and concern test because they don't cite it. Is there anything left of that test? I'm curious what Paul and Terry and others think.
I think RJR Nabisco is the test. No, I don't think there's anything left with touch and concern. But that doesn't necessarily. I mean, the thing they've left open is how do you interpret that test, and how do you interpret it in the context of the Alien Tort Statute, right? I mean, I think that the signal in RJR Nabisco was that it was the test because it was post-Kiobel and it referred to Kiobel. I think the court has already decided that the Alien Tort Statute is not extraterritorial, that's going to require Congress to deal with it. What they haven't decided, and what I think is noteworthy about Thomas's opinion, and maybe explains why the liberals joined it, is that they haven't decided what the focus is. And you know, I think that it may be that a majority of them would find that, you know, conduct that would be aiding and abetting on U.S. soil is enough, and it's enough even if some things happen abroad, because there's language in the decisions that say it doesn't have to be everything that happens within the United States, but it has to be enough. And so that's really the remaining question: how much is enough? You know, does it have to be a completed violation? Can it be 90% of a violation? Can it be enough conduct that is connected to the violation specifically, that the court would find that it's one of the other things that I found interesting about the opinion, and not necessarily happy, but the Harvard amicus brief introduced all this historical evidence, you know, going back to Jefferson and Randolph and the founding fathers, that really reinforced the fact that if U.S. defendants committed violations on foreign territory, that was exactly what the Alien Tort Statute was designed to deal with. And the court really doesn't deal with that. It doesn't even mention it. And you know, the fact that there's a memo from Thomas Jefferson, you know, saying that that the statute should read that way, you would think would be something that might be something they talk about. But that may be for another day. You know, I think that we're going to be fighting out, as we did after Touch and Concern, you know, what does focus mean now? So the focus is the new Touch and Concern, and I don't think they've resolved it. So I think we've got arguments. I think we've got very strong arguments about the idea that if U.S. corporations aid and abet from U.S. territory, that gets you around the presumption against extraterritoriality. And
Great, thanks,
we'll
Paul.
see.
We're a little bit over time. Terry and Sean, do each of you want a real quick final word before we close up?
Well, I would just say, I want to leave with an encouraging word. That is that this isn't over. And I want to say thank you, Charity, for including our chocolate company in this chance to be an amicus party in this case, and to work on this important issue. And thank you, Paul and Beth and Terry, for your work. And I'm just thankful to be alongside you all. And as I said, I'm optimistic about this. I think there will be a way forward, and I appreciate the people who support our little chocolate company and those of my other 17 colleagues in this amicus case. There are a lot of small chocolate companies around the world that don't do these kind of things, and I hope that consumers will find those little chocolate companies and support them. And one day we'll hopefully have this issue of child slavery and forced labor in the rearview mirror, and I hope that day is soon.
Sean, Terry?
I'll just briefly say that we have now a briefing schedule in our TV PRA case against the cocoa companies. It's a pretty long one, but I'll keep you all posted on our website about the status of that case, which could be our way into discovery, as someone mentioned. And I think, building on what Sean just said, first of all, I appreciate everyone's work and cooperation. We can't win this without a lot of people helping and cooperating together. And there's no reason in the world to deny yourself chocolate. Just don't buy it from any of these big companies. They're all using child slaves. If you go on to a website called slavefreechocolate.org, they list about 30 companies like Sean's that have been thoroughly vetted and don't use child labor. I will have to say, after my family tried Sean's chocolate, They won't let me buy any other chocolate but Sean's chocolate. They ask me repeatedly to order more, which I just did. So try it. Thank you.
Great. Well, Beth, Paul, Terry, and Sean, I want to thank you all so much. This has been super interesting. I'm seeing a lot of folks in the chat saying they really enjoyed the discussion. I view all of you as a panel dream team. So thank you so much for doing this again for a second time. The recording is going to go live for everyone who registered. You'll get an email with the recording and we'll put it live on our website in the next couple of days. So thanks so much to everyone for joining us. It was great having you. Thanks for the insightful questions.
Thank you,
Bye,
Charity.
everyone.
Great job.
Thank you.
Appreciate it.
Bye-bye.